going to talk about how we're going to provide legal assistance to low-income people in these times when all other assistance is being reduced or eliminated. Somehow our panel's going to solve that problem for you this afternoon. Most of the funds that are being eliminated by all of the government agencies these days, federal, state, local, and the financial outlook for both private and federal funds is not encouraging. So what are we going to do about legal services for the poor? What do they need? What kinds of legal assistance, and where will it come from? Private, public, wherever. What can we do and what can we hope for? Well, this is a group that's going to tell us all about that, and I'll introduce you to our panel members very briefly because you do have full biographies of them in the program if you need them at all. The members will have 5 to 7 minutes for opening remarks, and then we'll have about a half an hour for exchanges among the panel members. Then we'll close with whatever time is left. It's supposed to be a half hour for questions from the audience. I've been instructed to ask you to turn off your cell phones. I wonder whether I did that.
Yeah, good question.
Yes. Turn off your cell phones. Tell you that the panelists will remain afterwards for 15 minutes of chatting with you. In the book, they call it networking. And to thank our sponsor, Aiken Gump. I've never done that before. Now to our panelists. First is Peter Edelman, who is a professor of law at Georgetown, one of the true heroes of the Clinton administration, and there weren't many. Peter always fought the uphill fight for social justice, and he's still doing it, and I hope you succeed someday, Peter. Next is Frank Strickland, a very prominent Georgia lawyer, former head of the Legal Services Corporation. So unlike maybe one or two of us, he knows what he's talking about on this subject. Mr. Strickland is extremely active in bar activities, and you'll be happy to know, an active member of the Federalist Society. Cheer, come on, that's however, I've been told he was a wonderful head of the Legal Services Corporation. Next, Larry Tribe, and who doesn't know Larry Tribe? Long recognized as America's leading constitutional scholar. He taught constitutional law at Harvard for 40 years to half of America, including President Obama, and someday he's going to tell him how important judicial appointments are. I don't mean that. We all love President Obama. Professor Tribe is a founder of the American Constitution Society and now in charge of the nation's effort to provide access to justice in both criminal and civil arenas. I can't think of a more difficult and a more needed job than to be in charge of providing justice in America, and if anybody can do that, it's Larry Tribe. After that is Judge Inez Smith-Reed, who was my moot court partner yesterday, so I can tell you she's a very able judge, and she's a judge of the District of Columbia Court of Appeals. She has a really lengthy career, and don't mean years, I mean in experience, in government, private practice, as an educator, and as an author. There's little, if anything, she hasn't done and done with the utmost success. Then we have Justice Earl Johnson. He's a noted and liberal justice of the California Court of Appeals from 1982 for 25 years. Before that, he was the second director of the Legal Services Program in the Office of Economic Opportunity in 1965. So Justice Johnson was there from the beginning. He has, since 1965, fought for legal services. Whatever career he was in, legal, judicial, he always maintained his interest in and the fight for legal services for all. He's one of the first and foremost in that field. Then we have Chief Judge Robert Pratt, a United States District Judge for the District of Iowa. Before his appointment, he practiced as a legal aid lawyer, both with legal aid and in his own firm. He represented labor unions, civil rights plaintiffs, Social Security disability claimants, and low-income clients. You don't find many like that on the federal bench these days. And don't hold your breath, but we're glad to have Judge Pratt on the federal bench. So we're fortunate to have this kind of a panel. Whatever the subject would be, we'd be fortunate to have a panel with this knowledge and experience. And I'm happy to start this program with Peter Edelman.
Well, thank you, Judge. My assignment today is to lay out just a framework for the rest of the conversation. A little presumptuous for me to talk about the history and the framework of legal services with all the knowledge that's up here, and I don't want to say what others will say, but where I overlap, I think they will develop what I say much more fully, and where I make a mistake, given the knowledge here, they will be gracious. Talking about the history with Earl Johnson here is like the fellow who died, who'd been in the Johnstown flood, and he went to heaven and he asked, they said, you've been a good person down on earth and you can have one wish. He said, well, I want you to bring everybody together so I can tell them about the Johnstown flood. So they did, and as the appointed time came, St. Peter said, well, I've got everybody here, but you really ought to know one thing. Noah is in the audience. So, Earl. Anyway, here's the history and the present in a nutshell, just like Mel Brooks. See, nobody knows about Mel Brooks anyway. Before the 1960s, representation of poor people on the civil side was a combination of helping people out for free, pro bono as we now call it, and privately funded nonprofit legal aid societies in the big cities that did individual cases, and I'm guessing more for white people than people of color. And then as part of the war on poverty, and here's where Earl comes into it, and preceded a bit by models funded by the Ford Foundation, we got not only a program of federally funded legal services for the poor, but along with it came an ethos of doing cases that challenged structures and laws and policies for groups of people who were not being treated justly, and often working with people who were organizing welfare recipients and tenants and farm workers and others to pursue legal and political strategies for change. So those were the days. But the lawyers pissed off a lot of people, and besides, the courts began to change and became less responsive, and for a variety of reasons, the steam went out of the organizers and the activists. So not only did the Kennedys and Dr. King and Malcolm and Ed Medgar die, but so did George Wiley and Ed Sperrer, the lead organizer of the welfare rights movement, George Wiley, and the intellectual guru of the legal movement to create a guaranteed income, Ed Sperrer. And of course, there are others who we've lost along the way who were the greats like Gary Bello and others. Kennedy and Johnson gave way to Nixon. There was a brief moment of Ford and Carter, and then there was a lot of Reagan. Reagan chopped the funding for legal services, and Gingrich came along in the 90s and took another swipe by putting in the restrictions on class actions and representing various groups like inmates and immigrants, and worst of all, applying the restrictions to all the non-federal money received by any organization getting federal money. Now, mind you, the heyday was never close to perfect. The legal services have never reached more than a fraction of low-income people who have legal needs. But the federal money hasn't yet recovered from the Reagan attack. And if the federal money had kept pace with inflation, it would be something like $800 million now, and it's somewhat over $400 million, although that's up from about $270 million when the Democrats took Congress back 4 years ago. But that's, how about that history in 1 minute? That's far from the whole picture. The whole picture is that nationally there's about $1.3 billion. In other words, annually. The federal money's about 1/3. And the rest of it comes from states, and we now have 49 states. Wyoming joined recently, was the 49th state, so only Idaho is missing. And they put in money that adds up to a substantial amount. Law firms and lawyers are supportive with money as well as pro bono. Foundations do some, and then we have IOLTA, which most of you know, but it's interest on lawyers' trust accounts, and it would take me another few long minutes to explain that. But in any case, they're transactions that lawyers have where they put monies in escrow and it pays interest that previously wasn't paid to anybody, kept by the banks, and now is a substantial source of funding for legal services. We also have, as one piece of the picture, access to justice commissions, which have come along in the last 10 years. I chair the commission here in Washington, D.C., and Judge Reed is vice chair with me and is going to talk about our commission, so I won't do that because she'll tell you. As Judge Reinhardt said, the situation now, with all of the limitations that I've already explained, is worse than it had been in recent years because of the recession. So legal needs are going up very, very substantially. People are in big trouble. Federal money is going up a little bit, but because interest rates are in the basement, IOLTA has lost a huge amount of money, been cut in about half, and all the other sources are down. Although surprisingly, a few states went up in 2009 to the point where actually the total nationally of money from the states went up in 2009. We're reaching about half the people who come in the door, and the Legal Services Corporation, under Frank's leadership, put out a very good report a year or so ago that indicates, summing up all the studies that we have, that we're reaching about 20% of the people who have legal needs around the country. There's also a qualitative change, and I think we'll talk about this among the panel, in terms of what legal services lawyers are doing. Because going back to what I said about the 60s, there's much less structural work going on. The restrictions have something to do with that on the class actions, and I think that the unresponsiveness of the courts is certainly relevant. Big cities have been able to set up and fund freestanding impact organizations that do both litigation and policy advocacy and get around, therefore, the restrictions. But it's a lot harder. In fact, it's basically impossible in smaller states and in rural areas. And the whole enterprise of doing structural work, of using our advocacy on behalf of low-income people to really bring about substantial social change, is not nearly as robust as it should be. And so even though the courts are less responsive, We could do a lot more with policy work, with going to legislatures and so on, and we're not doing enough of that. That could be a lot stronger. And community lawyering, working with organizers and community building groups, that should be more muscular also. Again, I'm saying in a sentence or two things that should be developed and I hope will be in our conversation. And so our other wonderful panelists will fill in and say a lot more, and I hope that this gets us started.
All right, thank you very much. Our next panelist.
Thank you, Judge Reinhardt, and good afternoon, everyone. I'm delighted to be with you, and I want to start by expressing my appreciation to ACS for inviting me to be a participant on this panel. I want to begin by saying that my tenure on the LSC board from April 2003 till just recently in April 2010 was one of the most rewarding experiences of my professional career. There are many people who are now my friends, including Earl Johnson, who's a fellow panel member here, all of my LSC board colleagues, and so many people who work in the LSC staff in Washington and in our programs around the country, who have also become my friends. So it's just been a positive experience all the way around. If you excuse my reference to when I say we and our relative to LSC, because I'm so used to doing that, having done it for the past 7 years. So even though I just left the board, I still feel like I'm a part of the organization. And speaking of the organization, I thought it might be interesting to you for me to assume that perhaps you don't know a lot of what I call the nitty-gritty about how LSC is organized. I want to tell you a little bit about that. It was created by Congress in 1974 as a D.C. nonprofit corporation to promote equal access to the civil justice system in the United States. It's governed by an 11-member bipartisan board appointed by the President of the United States and confirmed by the Senate. Now, each president is authorized to nominate 6 members of the board from his or her political party and must also nominate 5 from the opposite party. The board elects its chairman and vice chairman on an annual basis. So I was fortunate enough to be reelected several times, so even though it was a tough audience. Congress provides the budget for LSC. The current level, as Peter mentioned, is $420 million. We experienced several years of what's known in the trade as level funding. In other words, no increase. But $420 million, I'm pleased to say, is the highest budget in the history of LSC. Approximately 96% of that budget is allocated to the 50 states and U.S. territories on a census-based population formula. The LSC board can't manipulate that formula. What LSC does is, with its staff, the staff in Washington is about 110 people, the full-time staff. The staff makes grants to various legal services programs around the country, currently in 136 programs in every congressional district. This makes LSC the largest funder of civil legal aid in the country. Not the only one, but the largest. Each of the grantee programs is an independent nonprofit corporation with its own board of directors. And these programs in turn employ lawyers to provide high-quality legal representation to low-income Americans. To give you some idea of the size of the organization, the grantee programs combined employ about 4,000 lawyers and about 1,400 paralegals and other staff. In a lot of instances, including, for example, the Atlanta Legal Aid Society, the programs have been very successful at leveraging themselves and raising substantial money from grants and contributions. Atlanta Legal Aid raises about 2/3 of its total budget from grants and contributions. Whereas in other programs, Mississippi, for example, I'm not being critical of Mississippi, but just to use that as an example, that program relies on the LSC grant for about 90% of its annual budget. As some of you may know, one of the first things we did as a new board in 2003 was to engage a new chief executive officer, and that was Helene Barnett, a distinguished lawyer from New York, who had had a long career, 37 years, with the Legal Aid Society of New York, where she headed the 200-lawyer civil division for a number of years. We decided early on that after having a couple of meetings in Washington, that what we needed to do was hold board meetings in other cities so we could visit our grantee programs. So during our tenure, we met in 21 cities. It was always a highlight to allow the local program to showcase what they were doing, and it was a tremendous experience for the board to interact with our programs around the country. Our key initiative under Helene's leadership was to increase the quality of legal services being delivered by these programs. We established early on a quality initiative to help fulfill that vision, and that included such things as new performance criteria, leadership mentoring to develop a new cadre of leaders for grantee programs, a loan repayment assistance program to retain and to recruit and retain legal aid lawyers, and that's now benefited approximately 200 lawyers in 46 programs around the country. We also focused on increasing private attorney involvement. There's a requirement in the law that each program has to expend 12.5% of its annual grant on private attorney involvement in one way or another. So we focused on increasing that by publishing an action plan which we called Help Close the Justice Gap, Unleash the Power of Pro Bono. We also began recognizing outstanding pro bono lawyers during each of our program visits around the country. That was another highlight of our visits to these programs. But perhaps the most significant thing we did during our tenure, and Peter touched on it, we commenced a study in 2005 of what was going on in the legal services community, how many clients were being served, and the like. We asked our programs for a 2-month period during 2005 to collect data for that period on the number of individuals they were unable to serve due to a lack of resources. The result of that was the publishing of what we call the Justice Gap Report. The long name of it was Documenting the Justice Gap in America, the Current Unmet Civil Legal Needs of Low-Income Americans. The short version was the Justice Gap Report. To me, the most compelling statement in that report was that for every person who sought help, another person was turned down. And to put some numbers on that, during that test period, we projected that our programs had served 1 million eligible clients. So that means that 1 million others sought service and were turned down. And there's no way to measure how many people didn't even seek service. So that became a real talking point. That is the Justice Gap Report. It had broad impact in the legal services community. And most significantly, Congress and the media adopted that phrase, Justice Gap, and began to talk in terms of the need to close the Justice Gap. We also published a revised version of that report in 2009, which confirmed the Justice Gap was still present. There's a substantial body of work that has resulted from the gathering of this data. And LSC has been able to make the Justice Gap a term of art, if you will, that's now understood by a much larger audience, as I said, the media and the Congress. In fact, it shaped the dialogue with Congress, and invariably, if we went to the Hill to talk to our committees, the mention would be made of the Justice Gap Report. So that was one of the most significant things that we did during our tenure. As I said a moment ago, when we began our tenure, the budget of LSC was $326 million. When we left, it was $420 million. That was about a 29% increase. And again, emphasize that's the largest budget in the history of LSC. The overall organization, 136 programs, operate a total of 918 legal aid offices with total complement of about 9,000 people. That's it's quite a large law firm. It's not one big firm, but if it were categorized in that way, it would be the biggest law firm in the country. I'm very pleased to say, though, that we left the organization in good shape, in good hands, and with a good relationship with the Congress.
Excuse me, that may be a good place to ask you if you can wind up quickly.
All right, I certainly will.
Okay.
I'll stop right there.
All of our speakers, you know, we only are supposed to take 5 minutes. I won't cut you off till it gets to 10, but I don't know how you're going to tell us all the things you should. Larry, this is going to be very tough for you. But tell us how to solve the problems in 5 minutes.
Well, I'll do my best, Steve. First of all, it's a great honor to be here. I'm surrounded really by the heroes of this broadly defined field. People like Peter Edelman and Frank Strickland, Earl Johnson, Judge Reed, Judge Pratt, have each made enormous contributions, and I'm proud to be among them. As Judge Reinhardt mentioned, I spent something like 40 years so far teaching some pretty remarkable students at Harvard Law School. The president, the chief justice, the next justice, she was my research assistant 4 years before the president was. These are some amazing people, and it wasn't easy for me to decide to stop teaching, and I'm only on leave, but I couldn't resist because justice gap puts it mildly. As the president recognized shortly after he was elected, and as the attorney general has recognized, we have a crisis in justice in America. And the crisis is dramatically understated by much of what you've heard, pessimistic though some of it may appear to be. Yes, it's true, 400 million is the highest number that LSC has reached. But as Peter Edelman pointed out, if you adjust for the cost of living, it's half of what it would be if it had just kept its original level. It should be 800 million now, and if it were 800 million, we would still be barely scratching the surface. As Frank Strickland pointed out, for every person who shows up and is accepted by the rather stringent criteria, you've got to have no more than 25% above the poverty level to be eligible. For everyone who is accepted by an LSC-funded entity, someone is turned away. And I'm quite confident, though we need much better measures of this, and that's one of the things that my initiative is trying to do, get better numbers, better metrics. Quite confident that if you looked at the people who gave up, who didn't even bother trying, it would be a much larger number. And we're only talking about civil defense. The crisis in indigent defense, about which there will be a panel tomorrow, is equally staggering. But it's honestly even worse than that. The whole system of justice in the United States of America is broken. I mean, I've visited other countries as part of this initiative since getting on board on March 1st. We've been to Poland, we've looked elsewhere. We are not anywhere near the top of the heap. Other countries do a lot better. And what I mean by that really refers not simply to people visibly at the lower end of the economic ladder who can't get the lawyering that they need, but it is the fact that the entire legal system is largely structured to be labyrinthine, opaque, confusing, inaccessible, incomprehensible, not user-friendly. I don't know how many more adjectives I can use. This legal system does not give people meaningful access to the things that they ought to be getting. Whether it's veterans who have to fill out astonishingly complicated forms, or people in the Social Security system, or people who confront mortgage foreclosure, which would be avoidable in many circumstances, middle-class people as well as people at the bottom of the economic ladder, they do not confront a system that is meaningfully accessible. At the Justice Department, we're going to be working partly with Ken Feinberg and making the $20 billion that BP has put on the table accessible. That's not going to be an easy lift. The basic fact is, if you think about justice in the broadest sense, access to outcomes, things people are entitled to have in order to make their lives work, we're not doing very well in terms of a legal system that makes it accessible. So what my initiative has done is define its mission rather broadly, as if focusing just on the very poor was not enough. We really felt it's like the canary in the coal mine. When you look at the problems confronted by the very poor, they give you a window into problems that affect really the broad range of American society. So we have met with state and federal judges, prosecutors, defense attorneys, legal aid practitioners, advocacy groups, groups that are trying to make systemic change, community organizations, representatives from federal, state, local agencies, the VA, HUD, others, in a broad effort to identify respects in which what we might describe as justice is simply inaccessible, and then the respects in which people are making marginal improvements in various places. That is, we've seen things that do work. We've gone to Philadelphia and we've seen they've got a program where lenders have to come to the table before mortgage foreclosure and have to engage in some meaningful mediation. Many times these programs depend on sort of energetic judges who grasp the nettle and don't think that their role is simply to preside passively atop some bench with a black robe, but to get in there and actually help people represent themselves. So Annette Rizzo, who's a judge in Philadelphia, has set up this mortgage program, and when you watch it operate, it's really inspiring. You see people sort of saving their lives, really, saving their homes, with lenders at the table who have been forced to be there and to engage in some meaningful negotiation. Now, given the time limit, I won't go on with all these examples, but what we have found is instances throughout the country, in Philadelphia, in Seattle, in Boston, and other areas, where things seem to be working. And what my initiative is trying to do is figure out what makes them work. Of course, more money would be great. If Congress were to step up to the plate and put a dollar value on these services that is commensurate with what they really represent, both the services of lawyers and the services of people who can help people help themselves even though they may not be licensed to practice law, we would have vastly more funding. But short of that, and it's a lift that is almost impossible on the Hill as it now exists, although I'm working with the White House and with the congressional sort of arm of the Justice Department to try to get more money for LSC, to try to get the restrictions pushed back. Short of that, we're going to have to find ways to do more with less, to be smarter, to find various kinds of serendipity and various forms of synergy. So, for example, you find people coming into medical clinics and to emergency rooms with what turn out to be legal needs. And there are these wonderful medical legal partnerships that were started originally in Boston and have spread to other parts of the country, where a woman might bring her baby into a clinic. The baby has terrible asthma. Maybe the baby needs a breathalyzer, maybe some medicine, but what the baby really needs is someone who, whether a lawyer or not, is trained to write an aggressive letter to a landlord to get the mites out of the carpet, which are the cause of the baby's asthma. There are often legal problems that people don't classify as legal problems. They have legal needs that they don't recognize. The reason they're not walking into LSC isn't simply that their neighbors have been turned down, but they don't even know that they've got a legal problem. So if you look at unmet legal needs in that sense, they are truly vast. Now, why would my initiative undertake to tackle all of that when it's hard enough just to increase the funding of LSC marginally or reduce some of the counterproductive and perverse restrictions on even private money with LSC? Well, the reason simply is that this is a problem that is so interconnected that just poking it in one place or another is not enough. One needs a sustainable effort to change the culture and enlist lawyers and others in community-based efforts that are networked, that are web accessible, that are linked to the administration's efforts in open government. And my bet is that because there's nowhere to go but up, because we really can improve the situation, it's better to tackle the problem in the large to energize people. That's why when we go to talk to law firms about their pro bono efforts, we don't set our sights very low. We talk about how, yeah, it's great that you've got X hours by associates, but how many of your partners spend at least 15% of their time in pro bono projects? And not just pro bono projects, but ones that are community-based, sustainable, that are likely to last after you feel that you've performed your altruistic service. And we are getting judges on board. Today, this afternoon, I met with Alex Kozinski, who's sort of Steve Reinhardt's evil twin, if I might say. But Alex is a great guy and a friend of mine, so if he heard me, he would understand the positive spirit in which I mean that. We met with Bob Katzman in the Second Circuit, who's got great initiatives on the immigration front. We met with Ray Fisher of the Ninth Circuit. We're meeting with other judges. Judge McKay of the Third Circuit is starting a pro bono project. We're trying to generate activity throughout the country. At the end of the day, I hope we will leave behind something that can go on and grow. And I've never done anything more meaningful in my life, so I'm excited to be doing it and hope to get your cooperation in moving it forward. Thanks.
Thank you. And next, Judge Smith.
Thank you. I'm going to be concentrating on the District of Columbia. The origins of our Access to Justice Commission actually grew out of an internal D.C. Court Standing Committee. We have a trial court and we have an appellate court, no intermediate court. And we first concentrated on trying to weed out race, ethnic, and gender discrimination within the District of Columbia courts. And then we quickly broadened and realized that the problem of access and fairness was much, much greater than what we were focusing on at that point in time. And we determined that due to the demographics of the District of Columbia, and these demographics included a very high poverty rate and increasing arrival of immigrants who were not proficient or had no proficiency whatsoever in English, ranging from Ethiopians who speak Amharic to Vietnamese and Koreans, Chinese, you name it, and the immigrant community included it. And so we consequently had conversations with the D.C. Bar, the D.C. Bar Foundation, legal service providers, and the D.C. courts to discuss the creation of the commission. And the commission was established in 2004 and began its work earnestly in the year 2005. We consist of about 17 members, 17 commissioners, judges, legal service providers, other kinds of attorneys, health professionals, a community representative. And key for us was the leader of our group. And we prevailed upon Peter Edelman to head our commission, and he has been in that capacity from the very beginning. We also determined that in addition to the key head, that there were some key relationships that had to be developed. We obtained the support of both of our chief judges. That was crucial, the trial and appellate court. We obtained the support of two large law firms, DLA Piper, who provided pro bono support for us, and Venable, who provided a space for our executive director. Also, it was necessary to get the support of the D.C. Bar and the D.C. Bar Foundation from a funding point of view, not only in terms of dollars, but also in terms of volunteer resources. And finally, we created for ourselves a District of Columbia Access to Justice Foundation to work on getting operational funds to support the commission. Now, let me quickly tick off some of our accomplishments, at least the highlights. Like the LSC, we issued a comprehensive civil legal needs study and report. Ours was issued in 2008, concentrating on the District of Columbia, and it's called Justice for All with a question mark. Our study is based on empirical data, surveys of legal service providers, court statistics, review of existing studies, including the Justice Gap study. We determined that about 17% of the district's residents live below the poverty line, and this includes 25% of its children. It's probably higher now in these times of economic constraint. We also discovered that the unmet civil legal needs are quite broad in scope, and they fall in the areas of housing, family, consumer, employment, education, wills, immigration, health, disabilities, and public benefits. We also discovered that 97% of the litigants in our courts, particularly in the areas of landlord, tenant, and family, are self-represented. We then, second, focused on improving conditions, first in the landlord-tenant branch of our trial court. And in collaboration with the D.C. courts, the Commission began to provide some Spanish language translation for opening statements. We had people coming to the landlord-tenant court who understood absolutely nothing because they did not speak the language and we had not accommodated them. We now do that. We provide interpreters. In addition, we depend upon Legal Aid Society, the D.C. Bar Pro Bono program, and others to provide on-hands legal assistance to self-represented litigants. And we've worked on changing the court's rules so that tenants can now prosecute their housing code violations right in landlord and tenant branch of our trial court. And we've been able to help some of the tenants avoid evictions, including evictions which are traceable to foreclosures on landlords. Third, we obtained public funding for civil legal services through our own local legislature, the Council of the District of Columbia. That funding began in 2007 at the level of $3.2 million, and then continued on at lower levels, 2.7 in 2008, 2.97 in 2009, and in 2010 it was up to 3 million. But in these times of economic constraint, the mayor put in for 2011 only $1.8 million, and we had to work feverishly to try to get that sum back up to a level where we thought we could live with the funds. And I'm happy to say that it is now at the level of 3.5 million, going from the district government to the Congress of the United States, which has to approve all of our funds. And these public funds have been used in several areas. One, in the tenant area, to provide same-day service to tenants who are in need of that kind of service. Second, to service residents in our poorest areas, Southeast Washington. In other words, we put the lawyers out in those particular communities. And then we have also used some of the funds to service the elderly, where the legal service for the elderly goes actually into the homes of the elderly to provide service. Another way in which we've used the public funds is to establish a community interpretive bank, which works on training interpreters in the language of the law and also in providing interpreters specifically to community groups. And that community interpretive bank now has 21 interpreters for 11 different languages. And then part of our funding was, of course, a loan forgiveness program, and that has been highly successful in getting people to go into public service careers. Fourth, we improved communications for low-income residents with legal needs within the courts. We updated our website to provide basic information in 6 different languages. The court also has begun to concentrate on translating key documents. For example, the landlord-tenant basic complaint and summons has been translated into different languages, Spanish, French, Amharic, Chinese, Korean, and Vietnamese. And we're now beginning to translate court orders into the language of the litigant. We have also established a number of resource centers for self-represented litigants. For example, our Landlord-Tenant Resource Center has serviced about 4,700 persons on an annual basis, and our domestic violence intake unit and intake centers has serviced about 5,000 people on an annual basis. And there are some smaller resource centers. We're also now working with our biggest administrative agency hearing arm to try to establish a resource center there for persons who have unemployment compensation cases, public benefits cases, et cetera. Now, the last point that I want to emphasize is that we have been trying to get more attorneys to engage in pro bono services. We've had conversations with a number of law firms around the changing economic pattern and also the need for increased pro bono services. Now, this has been an uphill battle because the economic conditions in the District of Columbia have deteriorated. And we recently, in 2009, published a report called Rationing Justice to show the extent of that deterioration. Just to give you a couple of examples, in our poorest community, the unemployment rate is now up to 28.3%. In the next poorest community, it's up to 19.5%. And with these unemployment rates have come increased cases of civil need, particularly in the areas of domestic violence and family. And concomitant with that has been a tremendous decrease in the capacity of the legal service providers to help out in this particular area. So I'm going to stop there, but that just gives you a nutshell view. Much has been done, but much remains to be accomplished.
Thank you. Next speaker is Justice Johnson.
I tried to game the 5 to 7 minute time limit by providing everybody with an 8-page handout. Consider it the
Who's our next speaker?
Consider it the footnotes. I will give you the headlines, and the details and the authority will be in that handout. I doubt many of you that are here today were also here to hear Justice Ruth Bader Ginsburg's address to the American Constitution Society in August 2003. But on that occasion, she made a very important point. She pointed out that Supreme Court justices are becoming more open to comparative and international law perspectives. And then she said, while you are the American Constitution Society, your perspective on constitutional law should encompass the world. And in no area of the law is Justice Ginsburg's admonition more relevant than in an issue I want to address today. Equal justice for poor people as a matter of right, not charity or government largesse as it has been for so long, but as a matter of right. You see, by the early 20th century, most European countries already had statutory rights to counsel in civil as well as criminal courts. One exception was Switzerland until 1937, when the Swiss Supreme Court stepped in and found a constitutional right to counsel in civil cases in that nation's constitutional guarantee that, quote unquote, all Swiss are equal before the law. Determined they can't be equal without lawyers, indigents don't have lawyers, government has to provide the lawyers. Another exception to the general rule for Europe was Ireland until 1979, when in a case called Erie versus Ireland, the European Court on Human Rights held that member states, including Ireland, are required to provide free counsel to indigent civil litigants in the regular civil courts because of the quote and unquote fair hearing guarantee in the European Convention on Human Rights and Fundamental Freedoms. Then, in 2005, the European Court expanded that rationale in a case called Steele and Morris versus United Kingdom, holding that a fair trial also requires, and I quote again, that a litigant is able to enjoy equality of arms with the opposing side. This implies that if the other side has a lawyer, the indigent litigant must be supplied one too, which is what the court held in that case.
It's a new Second Amendment basis for the right to counsel.
There you go. Whatever it takes. But while waiting and hoping, American courts will indeed pay attention to constitutional developments elsewhere and catch up with the European courts on this issue, California, my home state, is trying a legislative approach. It is a limited experiment with providing equal justice as a matter of right and providing counsel when needed to achieve that equal justice. I don't have the time to tell you the story of how that experiment came about, but I did want to provide a brief overview of the legislation itself. It is called the Sargent Shriver Civil Counsel Act, a man well deserving that honor, but also it didn't hurt in getting Governor Schwarzenegger's signature on the bill. It provides roughly $11 million a year generated by a new set of post-judgment fees to fund 6 years' worth of pilot programs, meaning a total of $66 million for the project. The funding begins flowing on July 11th, 2011, a little over a year from now, and the pilots are expected to start operating in October of that year. The first round of grantees get 3 years funding, and there will be a second round in 2014, some of which will probably be renewals. Between now and July 2011, there will be an RFP process to select the grantees, and a committee of judges and legal services lawyers and other stakeholders will be making those decisions. One of the important features of this is that in addition to providing counsel when appropriate, their courts are expected to engage in innovations that will, along the line that Larry Tribe just mentioned, will make it easier for people who don't have lawyers to access the system. California has already a good system of self-help assistance centers, so the focus of this will be on identifying cases where self-help assistance is insufficient and providing lawyers in those cases, and especially providing lawyers in those cases where the other side is represented by counsel. Hence, what the Shriver Counsel pilots seek to provide is not a right to a counsel in every case, but a right to equal justice in each case, what the European courts would call effective access to justice and equality of arms. So, admittedly, the Shriver Counsel legislation represents only a baby step, but an important one on the long, long road to making good on the Pledge of Allegiance and its promise of justice for all.
Thank you, Justice Johnson. Now, Judge Pratt.
Thank you, Judge Reinhardt. Well, first of all, I think that our attitude and our language about discussing legal services for the poor has changed since I was at Legal Aid in the early 70s. When I was there, we worked for the Office of Economic Opportunity. Many of you have never heard of that. It was the Legal Services Corporation. The organized bar was our opponent. We prided ourselves on the organized bar being our opponent. I recall many fights with our local bar association about we were representing people who were, quote, over income. One of my favorite anecdotes is to tell the story about the first task at Legal Aid was to take an income form and go through it with the client, at the end of which, if they were over income, you would tell them, I'm sorry, I won't be able to help you. And the client would forlornly look at you, having been moved from agency to agency, and say, does this mean I have to get a real lawyer? Yes, you have to get a real lawyer. So while our attitude with the transformation of the bar's attitude, and Frank Strickland, I think, adequately described how the bar has moved in a good direction, our actions have not matched our rhetoric. learned hand said a long time ago, the one rule of democracy is thou shalt not ration justice. And as Professor Tribe has shown us and the other people have, we have rationed justice. Our legal system is accessible by only the top 1% of income earners in the United States. So my task was to talk about the efforts beyond legal services and what we can do to try to narrow this gap that the other participants have told you clearly exists. And I have a little advantage here because I am the only lawyer that left legal aid and got poorer clients. And the reason I was able to do that is a confluence of events. When I was at Legal Services, I did a lot of now prohibited actions by legal services lawyers. They can't do Social Security disability because it generates a fee. When I was at Legal Aid, we could do fee-generating cases. So the confluence of me leaving legal services and Ronald Reagan coming to presidency is that he slashed the legal services budget by 2/3, and he threw 400,000 people off the disability rolls. And so it's an ill wind that doesn't blow somebody some good, and thereby creating what became my practice. And so the first thing I want to talk about is the first choice for people who are now unable to access our legal system is capable, competent legal services lawyers who stay there and make a career of it, and just like law firms who specialize in what Peter Edelman called structural change, or we used to call law reform, substantive changes in housing, consumer issues, all kinds of issues like that. The second way to meet this unmet need is large law firms who make, you know, when I read these stories about per partner profits of millions of dollars, they clearly have the capacity to know what they're doing in 1983 actions, civil rights actions of all kinds, but that hardly meets the needs that we have. So the third solution is what I built my practice on. And let me tell you, for you young lawyers out there, if you think these high-profile cases that you read about in the Supreme Court, the federal courts are day by day depriving people of things that don't get in the newspaper. If you want to build a career around something other than laboring in a factory, there are a number of areas that you can do good and do well. And so the third way to meet the unmet legal services needs is representation for low-income clients and contingent fee representation where the amount of the fee is regulated. I'll give you just a few examples. Social Security, veterans, unemployment, pro se, truth in lending. There are hundreds of areas that are underserved because lawyers don't want to get in there and figure out the system. These wonderful statutes that the Great Society Congresses and Congresses since have passed, allowing middle income and poor people access to the law, are no good without a good lawyer. And lastly, I want to tell you that when you do get to federal court with these kinds of claims, you have to remind the federal judicial officer of the oath that every federal judge takes. 28 U.S.C. 453 says, I promise to do equal right to the poor and to the rich. And sometimes you have to remind them that the poor come first in that oath. I tried to keep within my limit, Judge Reinhardt.
Yes, thank you. I'm just interested in the kind of judges you have in Iowa. I'd like to know how they do if they came into our courts and said, I just want to remind you about what your job is, and the poor come before the rich. I don't know how they do in those cases in California, but I'm glad to hear about Iowa. I hope you must have taught them a lot of good law there.
Pardon?
I said you must have taught them a lot of good law in Iowa, those district judges.
I do the best I can. I always tell people, they ask me, how'd you get appointed? And I said, you know, I always follow James Goulden wrote the book the bench warmers. And for you law students out there, Judge Reinhardt and I have discussed this before, there are 2 rules for becoming a federal judge. You might want to write these down. It's in The Bench Warmers by James Goulden. The first rule is you should have the good sense your first day in law school to sit next to a future U.S. Senator. The second rule, if you can't comply with that rule, the second rule is to have the good sense to pick as your first law partner a future U.S. Senator.
Well, we're now going to have whatever comments anyone has on the panel. Justice Johnson gave us a good start. If all of you would get a Sargent Shriver system in your states, we'd be well on our way to starting, but it's still quite a start. What are your thoughts about whether we're really going to be able to provide the kind of services that poor people need to function in this society? Professor Trabb, how do you feel about how we're going to be doing?
I sort of focus not on predicting, but on just trying to do the best we can. I mean, somebody once said, if you live by the crystal ball, you've got to like to eat ground glass. It's not my favorite diet. I think that a lot of the most aspirational things that are around are essentially structures that have promise that won't be fulfilled in the near future. I mean, I would be delighted, but somewhat surprised, if I saw the pilot programs of the Sargent Shriver Act, which I celebrated when it was enacted, actually funded, given California's situation. But even if they're not funded, sort of putting in place structures like that with criteria for making selections among cases is at least a start. I mean, it's a little bit like what one might say about the sort of the healthcare reform. I mean, it's undoubtedly disappointing to a lot of people. It doesn't have a public option, but it sits there as a platform on which something eventually might be built. I don't think that the United States is going to, in the very near future, close what looks like the justice gap. But I do think we will gradually do better. And one of the ways we may be able to do better is by generating better evidence. And one of the things that does seem to move lawmakers is proof that a lot of what they do is sort of penny wise, pound foolish, that a lot of the unmet legal needs that they simply look the other way at are things that are going to cost them much more when people who are economically deprived end up sort of entangled in the criminal justice system, swelling the ranks of those who are in the corrections process and ultimately costing the society more. So my hope is that evidence about how much you can save by pretrial diversion, evidence of how much you can save by avoiding needless foreclosure, evidence of that sort will make a difference. I gave a little keynote speech to a group called the National Institute of Justice a few days ago. There were 1,700 people there hungry to do sort of research, and other people there available to provide funding to provide an even stronger evidential base under some of our generalizations. I mean, even some of these numbers that Frank Strickland has mentioned that have become almost urban legend, that 80% of our legal needs are unmet. When you try to unpack them and you're actually sitting and talking to a lawmaker, what does that really mean? What do you mean by an unmet legal need? How do you measure it? I have to say that I would love to see some much more convincing and elaborate study. Now, I know some people would respond, we've studied these problems to death, we need action. And I do think we need action, but I think generating more empirical data will be part of what's useful to do.
That's one of the major purposes of the pilot projects. They are going to be evaluated. They are, after all, just pilot projects. There are going to be a few courthouses in which they will be operating with a few legal services lawyers and private practitioners involved in providing the service, and with the courts having presumably introduced innovations, and all of that is going to be studied, and we hope to have some evidential basis on which we can go back to the California Legislature at some point and say,
Mr.
Here's the
Strickland?
case.
Right.
for-
Okay.
No, I think that's terrific. And in the pilot projects that my initiative is likely to be sort of engaged around the country, that's part of what we'll be doing, trying to build the generation of empirical data into the project itself.
Mr. Edelman?
I want to address your question, Judge, from the local point of view. Everybody here, some of you go to work for the federal government, but most of you are going to do whatever you do out in local communities. And we here in Washington are pursuing the civil Gideon idea without actually talking about civil Gideon. We are simply working in a whole variety of ways to increase the volume of legal services that are available, and we're doing that by organizing within primarily the legal community. So as Judge Reed said, she told you the number, that is to say for this coming fiscal year, $3.5 million. We're a small town. That money, when we got it 5 years ago, enabled us to increase the number of legal services lawyers, legal aid lawyers in our city by 25%. It enabled us to double the number of lawyers that we have in practice across the river in Ward 7 and 8, where there's such high concentrations of poverty, double the number. And it enabled us to double the number of lawyers in landlord and tenant court. And so when we were threatened by the mayor trying to cut that funding in half just within the last month or two, we got every living ex-bar president who's not a judge or who's not working in the federal government to sign a letter. We got the archdiocese to go down and lobby, personally, their lobbyists to lobby on this question. We got community groups from all over the city to write letters. We would walk into our council members' offices and we would say access to justice, and they would say we know about that. And so that's the kind of thing. That's on the public side. On the private side, it's about increasing pro bono, which is extremely important, as well as increasing the financial contributions from law firms, which we have done, which we are working on. And we're on the verge right now. We're going to announce within the next week a major senior lawyers pro bono initiative, with 8 of the largest lawyers in the city being founding partners in that. And we're going to increase, again, effectively, the effective number of people delivering legal aid to low-income people by 25% through that initiative. DLA Piper has agreed, because we've worked together so much, and we have put in place, it's been there for a year, my student Betsy Gwynn is out here, who worked in the project, so that we have a poverty reduction support center that's a partnership between the Legal Aid Society and DLA Piper and Georgetown Law Center. So if we need to get down to concrete, we must do all these things nationally, we must do all these things at the state level in big states like California, but put our communities together, put our shoulders to the wheel in very concrete ways where we can accomplish tangible outcomes, and that, to me, is the route to civil Gideon.
If I may just tack on to what Peter is saying, one of the things that I discovered along the road, and I've been at this since 1996 in terms of access and fairness, is that it is equally important with the pilot projects and the public funding to get everyone in the system vested in the notion of equal justice for everyone. And that's starting with the judges. I mean, not every judge who mounts to the bench understands the need and understands the meaning of the concept of equal justice for all. And so we work very, very hard within the court. And when we first started out, there were a handful of people who were vested in this notion of equal justice for everyone. And now I'm happy to say that it's not just the chief judges, but our trial judges. A majority of those trial judges now begin to understand what it really means to work hard for equal justice. So it's not just running out and getting the pilot projects and the public funding, but it is also spreading the word and getting people invested in the notion that equal justice is everyone's responsibility.
Mr. Strickland, what do you think about Judge Pratt's suggestion that lawyers go into sort of contingency fee practice where you have small amounts like Social Security cases, veterans cases, and we ought to depend to some extent on lawyers going into that kind of practice instead of large firms.
Well, of course, a legal services lawyer in a federally funded program, as Judge Pratt pointed out, can't take a fee-generating case. Other lawyers can certainly do that. It's a real challenge, however, I could make a case that the lawyers in the United States should be ashamed of themselves in terms of how much time they commit to representing indigent clients. Theoretically, if there are 1 million lawyers in the country, and remember the example I gave you a moment ago, 1 million people were served by LSC programs and 1 million were turned away. Well, this is unrealistic, of course, but if each of those 1 million lawyers had taken one case, then it would have served the 1 million clients who were turned away. But of course, the lawyers are all geographically dispersed, and the clients are probably huddled in large metropolitan areas. But I know in the state of Georgia, the level of pro bono participation is not very good. And I'm on the Board of Governors of the State Bar, have been for a number of years, and we've been singularly unsuccessful at convincing lawyers either to give an hour of your time, or if you're not going to give an hour of your time, then whatever your hourly rate is, contribute that to one of the legal services programs in the state. No luck. So it's a real challenge to get the attention of lawyers to undertake those kinds of cases, whether or not they're fee generating. But it seems theoretically, following Judge Reinhardt's question, if they're fee generating, it ought to attract the attention of more lawyers than currently are doing those kinds of cases.
Judge Reinhardt, if I can chime in here. The Social Security Administration is the largest adjudicative body in the world. They decide 500,000 cases a year. There's a current backlog of 750,000 people who have either paid into the system or whose income levels are so far below the poverty level that they qualify for what's known as Title 16. The Congress in the Stimulus Act appropriated over $1 billion to hire 105 new administrative law judges. I gave a talk last summer at the Judicial Conference of the Social Security Administration law judges in San Francisco. They want to do right. 2/3 of the people that appear there are unrepresented, okay? If you look at the difference between people who show up with a lawyer and people who don't, you can make a substantial difference. You can't by doing 2 of those cases on a pro bono basis, but you can if you know the ins and outs. I convinced Litigation Magazine, I'm the author of an article that's coming out this month. They publish 4 times a year, the American Bar Litigation Journal, called Social Security Judging. I've tried to get my Article 3 colleagues around the country to take an interest in these cases because, believe it or not, the Social Security Administration had an official legal doctrine, I think Judge Reinhardt's familiar with this, called non-acquiescence, where they didn't follow the dictates of their courts of appeals and the district court. So to me, it's an outrageous example of governmental misconduct that can be attacked by our civil justice system, and the kind of structural reform that the speakers have talked about today, you can actually do. But it's not limited to this, to just this area. So I'm sorry to chime in like that, Judge Reinhardt. Those are the numbers.
Well, we're about to the time for questions, and we'll turn to the audience. Do we have a mic somewhere?
Hi. I guess I just wanted to make a comment more than really a question. My name is Sarah Niles, and I'm an attorney with the Civil Rights Division at the Department of Justice. And I just wanted to point out that we at the Civil Rights Division bring charges of discrimination on behalf of individuals, not dependent on their income level. And we're really working now on an initiative to kind of get out the word to community leaders that their constituents can come to us directly and complain about discrimination. And I guess that, if what I'd like to do is just kind of put that out there as something that, we'd like to let people know that they can have access to justice without having a lawyer, but it's just getting the word out to people that resources are available, both through the Justice Department, and I also know through various Attorney General's offices around the country.
Thank you. I think we have a question over here. If you
Alan Morrison, George Washington Law School. I want to follow up on what Judge Pratt said about the Social Security and VA cases and the possibility of fees, at least until this last Monday, when the Supreme Court decided a case called Astru, in which it said that the Treasury Department can offset against fees earned under the Equal Justice Act that belong to the lawyer in terms of having earned them. The court read the statute to say that it really belongs to the client, and therefore the Treasury can take the lawyer's fees. If there was ever a decision that is going to discourage lawyers from taking those kind of cases, this is it. And this was a decision made by the Bush administration to assert this policy. It hadn't done so for many years. The Obama administration defended it in court. And so I want to ask my friend Larry Tribe if he is willing to work and the administration to get them to change this policy or get the statute changed, because sure as we're sitting here, no sensible lawyer is going to take a Social Security or a VA case to go to court, even with a very high percentage of winning, if they know their fees are likely to be turned over back to the government and they're going to end up with nothing.
Well, it was a disappointing decision, but I think an utterly predictable one. All 9 justices did conclude that, unfortunately, the Equal Access to Justice Act awards the fee to the prevailing party rather than to the attorney. And so even though there were 3 justices, Sotomayor, Stevens, and Ginsburg, who made the point, very similar to the one that Alan Morrison has made, that this is going to make it more difficult for people with limited income to find attorneys to represent them. Nonetheless, it's something that could be changed really only by Congress. Now, our Office of Legislative Affairs, which is independent of my office, obviously is going to be taking a look at this. I'm certainly one who is not very hard to convince that this is a statutory decision that actually doesn't even necessarily represent what Congress had in mind, because in 1996, when the Debt Collection Improvement Act, which was involved in this case, was passed, the Treasury Department was not applying offsets to attorneys' fees. So Congress, in choosing the language that it did, in making the fee award to the prevailing party rather than the person who did the work, the prevailing party's attorney, may not have actually intended the outcome that followed naturally from its language. So it may well be that Congress could be induced to correct this decision, but before the Justice Department comes to its own sort of collective view on it, I've now learned, being in the government for a while, that that doesn't happen overnight. Each of the components of the Justice Department, you just heard someone speaking from the Civil Rights Division, the Civil Division would weigh in, the Criminal Division, it's going to be a process. And the Access to Justice initiative in the Department of Justice will be part of that process, and I'm a likelier ally of the outcome that Alan describes than some, but I can't make any commitments without studying it further. And so I can't tell you what DOJ will do.
Hello, I'm Patricia Lee with West Virginia College of Law. And earlier, the panel discussed a number of great ideas and solutions about really beginning to close the access to justice gap from court-developed pilot projects, pro bono services, LSC, maybe even contingency fees. My question is, what do you think should be the role, and maybe this is a question for Peter or any of the members of the panel, the role for private or public universities across the country, both urban and rural?
Well, one thing I can say quickly is that I've been inspired by what law schools are doing, law school clinics. I mean, I went down to Miami and I saw how the several clinics there, including an award-winning clinic for Haitian relief, had really stepped up to the plate, both after Katrina and with the disaster in Haiti. And it turns out that there are lots of clinics out there who are not as fully energized as they might be, that their resources haven't been always tapped as fully as they might. And when I went to Poland, I saw the law school clinics there that had learned some interesting lessons from the law school clinics in South Africa. So people like Martha Minow, the new dean at Harvard Law School, are going to be convening efforts among law schools to sort of beef up their clinic efforts. To some extent, there's some legislative pushback. A number of the state legislatures are essentially trying to punish law school clinics for engaging in systemic reform efforts, basically saying we don't want to fund a clinic that might sue us. But subject to that, and some of those efforts have been pushed back, I do think there is a major role for law schools to play. I mean, they've obviously tried through loan forgiveness programs and others to make it easier for their students to go into public service, but even before the students graduate, there's an awful lot of intelligence and energy there, and not only in law schools, I mean in colleges as well. You don't have to be a law student to be trained in even some fairly arcane areas of law to be of help in particular limited contexts, whether it's sort of foreclosure or something else.
I would just add, I think that we should think about it in a somewhat broader way. Clinics are absolutely fabulous, and at Georgetown, I think we have, maybe along with NYU, the largest clinical program in the country. I would say, however, that in terms of the scale of helping low-income people, remember, it's an educational thing, and so the number of cases that are actually being handled is relatively small. And I think as an educational matter, it's vital, both in terms of people then being able to go out and do some of these things in practice, even in learning how to do things that are going to be more broadly applicable. But Alan Morrison, who just spoke, and I have been talking, he's been pushing me about how can we invent new kinds of other pro bono opportunities for students to partner with law firms, to go out and work in the Office of Administrative Hearings, for example, locally in D.C., other ways in which they can do things either on an externship basis where they do get academic credit, which can be greatly expanded, or even on a voluntary basis where they're making a contribution of their time. So I think we need to broaden our sights about how do we infuse this culture more across the board in our law schools.
But could I just add one thing, though? I mean, I very much agree with Peter that the model of really intense clinical legal education, sort of one-on-one, really getting to know your client and so on, that's a model that has a kind of very finite ceiling in terms of the number of people it can help. But that's not the only educationally valuable model available at law schools. What impressed me the most about the Miami clinic was that they were able to mobilize people for sort of wholesale, quick, short-term emergency, sort of first responder relief, in which they reached out to all the people who had, I guess, been transferred from Haiti to Jackson Hospital and provided quick, vitally useful help in a rather sort of intense way. So I don't think we should give up on the idea of reaching substantial numbers. I mean, right now, in the Gulf, there are all kinds of legal needs. People don't know how to apply for various things, no matter how well the government does or Feinberg does with respect to the BP fund. People are going to be confused, and there will be opportunities for kids to be of help.
Hi, my name is Tom Spragley. I'm a law student at Columbia Law. Professor Tribe and you and others on the panel mentioned that there are many people who actually don't really know the legal problems that they have or that they can be solved in a legal context. And I was wondering what can be done for that? Is there an education and outreach program that could be done?
Well, there's, huge educational needs, civic education, giving people a better understanding of what the legal system is all about and how it works. But it's also a matter of finding the places where people enter the system with a set of problems that can be diagnosed, more or less, by people who get some kind of training. That's why in microcosm, the medical legal partnerships that have been begun and then advanced by someone named Rebecca O'Neill in various parts of the country are sort of a good model. That is, you have medical professionals, not always doctors, but often doctors' helpers and sort of nurses, physicians' assistants, who are sort of trained to recognize on a fairly simple grid what some of the legal issues might be that underlie some of the symptoms that are presented by patients. And then you have sort of help desks of people who are often law students or college students supervised by lawyers who are trained sort of to translate that recognition into some possible legal course of action. And it seems to me that finding the places where people sort of enter the system with a variety of problems that turn out to have a legal underpinning is something that can be generalized.
I would just add, though, that we have a real dilemma with that. We have talked a lot about doing better outreach locally, which we should be doing, relating to various places, whether it's health or a community center of some kind, where people come, churches, to take a kind of a street law concept, or at least a know your rights concept, and get them to understand that they may, if they think about it, they may have a need for a lawyer. And then we look at our system of providers, and they're up to here. They're turning people away. I mean, it really is, has that frustration about it. So it's absolutely right. The things Larry is talking about are what we should be doing. But if we don't have more lawyers, it's tough.
Hi, my name is Kathleen Karen. I'm with Global Workers. I have a question about accessing LSC services, because it had been said that it's hard to quantify the people that don't have access to it. But when you look at the restrictions, some of it's very quantifiable. So my question is about temporary workers that come to the United States on legal visas. They're here in this country legally, and the vast majority of them are not allowed access to legal services. So we're talking about domestic servants, working for diplomats. We're talking about au pairs, summer camp counselors, and the most of the H-2B workers who are construction workers, landscapers. So I would like the question is, what is the logic to exclude workers that qualify? No question they qualify by income, but why would we exclude them when they're the most vulnerable workers, because they have no idea where to go to access legal services, and they're only here for a temporary amount of time. So if there is no logic, why is it so politically difficult to get those workers included in access to LSC? Thank you.
If I may make a comment on that, it's not necessarily logical. I would agree with you on that. However, in the mid-1990s, there was an attempt to defund the Legal Services Corporation in its entirety. And as a result of a compromise which installed these restrictions, which are really not in the law, they're in the authorizing language each year in the budget. That was a compromise that essentially said, all right, we're going to keep the Congress is going to keep funding LSC, but we're going to install these restrictions so we don't hear from our constituents about legal aid lawyers suing them. So it's a delicate balance on the restrictions, and the example you gave, I think, is just an unfortunate result of that. But as I said, the compromise was, if you want funding, you're going to have to accept these restrictions, and they've been contained in the authorizing language every budget since then. So
the political answer is... Go ahead. Yeah, the political answer is that when you talk about domestic workers and that sort of thing, that they're just sort of their exclusion is the byproduct of agribusinesses' interest in making sure that no farm workers got representation, or that none, the vast majority of them who are illegal, undocumented aliens didn't get represented. So it was a sort of a broader stroke than they needed probably, but they wanted to make sure of that.
And I would just add, the Obama administration did propose to end many of the restrictions, not all, but many of the restrictions last year, and did better in the Senate than in the House, because one of the key restrictions is the restriction on spending non-federal funds that you have as a legal services organization, which, if you could change that, would free up money to be spent on various things such as that issue. And it was a Democrat, Mr. Mollahan of West Virginia, who was the chair of the relevant subcommittee in the House, who in conference essentially carried the day, and they didn't take out, they took out one or two restrictions, but not most of them. And he's recently lost a primary and will not be in the House of Representatives in the future.
Not for that reason.
No, not for that reason.
But he hasn't left yet, and in fact, the administration hasn't given up.
Well, on that positive note, it's time for your networking. There- I'm also supposed to remind you of the rest of the program for this afternoon, if I can find that. There's a panel at 5 o'clock. Panel. Oh. There's a book signing with Linda Greenhouse.
We'd love to get this far.
Then comments by